Um, Make the record clear, we're not on Zoom and running live on YouTube. The still in effect. There's no one else in the Zoom room, but I can tell you who is not in.
I had joined without video.
Have someone new. Hold 1 second. Person using Danielle's iPad, can you identify yourself, please?
Yes, it's Danielle.
Okay, you gotta tell me who you are.
Oh, I'm a cousin of Carnell's Watts.
Okay, and are you a witness to this? Is there a possibility you could be a witness in this matter?
Oh, no, no, sir. No, sir.
Okay, and is anybody else with you?
My daughter and granddaughter, but they're in school.
No, I'm at with you right now.
No.
All right, thank you.
Name, please? I need a list name.
Can you give us your full name, please?
Danielle Parker.
Parker? All right, thank you, Ms. Parker. All right.
Thank you.
All right.
No, sorry, I think I had previously asked you, had you seen a portion of a surveillance video from an A Eagles Coney Island back on the 19th of July of 2020? Do you remember me asking you that question?
Yes, sir.
And your answer was that you remember seeing that?
Yes, sir.
And do you remember my next question was, did you recognize anyone in that surveillance video? And your answer was yes. Do you remember that?
Yeah.
All right, now, sir, Judge, may I approach the witness?
Yeah.
Judge, for purposes of identification, I'm approaching with a scene still from what has already been admitted as People's Exhibit number 4, which would be the scene video from 9122 Dexter, which is the Coney Island that's in question in this case.
Right.
Sir, do you recognize what I am showing you? All right, is that a scene still from the surveillance video that I showed you in regards to the Coney Island back on the 19th of July of 2020?
Yeah.
Right, and in that particular still, are you also able to recognize individuals that are in that particular still?
Yeah.
All right, first I'm gonna move the admission of People's 43, Judge.
No objection. You got it.
Now, sir, I'm going, may I approach the witness again, Your Honor?
Yeah.
Now, sir, I'm gonna hand you this red pen, and I'm gonna ask you to first circle the individuals that you recognize. May I approach, Your Honor?
Yes, sir.
Thank you, Your Honor. I'm going to first show defense counsel. May I approach again, Your Honor?
Yes, sir.
Now, for purposes of this exhibit, sir, is it fair to say, or how many people did you circle?
3.
You circled 3, and we're going to start with the individual to the farthest right. Would you describe who you identified, or tell me who you identified in this particular case?
Carnell Wesley Watts.
And what is Carnell Wesley Watts' relationship to you?
He's my son.
All right, and for the record, would that be an African-American male? Oh, actually, no, strike that. What is your son wearing in this particular photograph?
Wearing a blue jogging suit with like almost a line striped down the jacket and some shoes that match the stripe on his jacket.
And that's the individual to the farthest right of this exhibit
Yes, sir.
that you identified?
Yes, sir.
What about the second individual that you identified?
Yeah. Brandon Mosley,
And what is Brandon Mosley wearing in this particular photograph?
a white t-shirt.
And would that be the person just to the left of Carnell Watts?
Carnell Watts.
And what about the third individual that you identified?
Quinn Antoine Wood.
And would that be the person to the left of Brandon Mosley that you identified?
Yes, sir.
And what is he wearing?
Great job.
One moment, Your Honor. Now, sir, back on the 19th of July of 2020, were you physically present at that particular location?
Should you say that again, sir?
You know what, that's right, I have nothing further. I have nothing further.
Just a few questions. Good afternoon, sir.
Good afternoon.
You testified that you know Mr. Watts, you know Mr. Willis, you know Mr. Bokosi, is that correct?
Yes, sir.
And these individuals, you see them often? Did you see them often?
Every day we live together.
They live together at your house?
I live with Connell Watts' house,
Okay.
and Brandon and Courtney live there.
May I ask you, from your personal knowledge, if you know if any of them were carrying weapons or guns?
I have an idea, sir.
No idea?
I have an idea.
That's fine, thank you.
I have no problem. Certainly, Judge. Commissioner Brooks?
May I have a moment?
You can excuse this witness though, John?
I have no further questions, Judge. Man, thank you, Judge.
Can we excuse this witness?
Please, Your Honor, I'm sorry.
All right, thank you, Mr. Rogers.
Thank you, sir. Judge, may people call the next witness?
Yeah.
Sergeant Shannon Jones.
You swear our affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Before the door twice, yeah, repeat this. May I proceed?
Thank you, Judge. Good afternoon, ma'am.
Good afternoon.
Would you mind stating your name for the record, please?
Shannon Jones.
How are you employed?
I'm a sergeant with the Detroit Police Department assigned to homicide.
And how long have you been with the City of Detroit Police Department?
20 years.
You said you're currently assigned to the homicide section?
Yes, sir.
Were you working in that capacity back on the 19th of July of 2020?
Yes, sir.
And were you also working the next day on the 20th of July of 2020 as well?
Yes, sir.
Did your duties bring you to the area of 9122 Dexter in the City of Detroit?
Yes.
What brought you to that location?
We were recalled out to a fatal shooting scene with multiple victims.
And when you say we were called out, or who are you referring to?
So that would be the unit that I'm with homicide. There's different squads. It would be the homicide task force that was responding out to that scene.
So the task force comprising of you and other individuals had to go to that particular scene?
Correct.
And when you got the information that it was a scene with, what you said, multiple victims,
Correct.
did you go to that physical scene?
Yes, I did.
And did you see any evidence that led you to believe that the information that you'd been relayed was true?
Yes.
What did you observe?
Upon pulling up, the scene was contained with the officers securing the scene. I observed a male victim lying in a pool of blood in the parking lot of the location. Kind of in front of the door, the location is a Coney Island. I'm also directed inside the Coney Island. There is another male lying in a pool of blood inside the Coney Island, where the waiting area would be for your food.
Now, Your Honor, may I approach?
Yes.
I'm approaching with what has already been admitted as People's Exhibits 5 through 22, Your Honor. And I'm just gonna ask you to look through these really quick.
Okay?
Sorry.
Yes. Okay.
Do those photographs fairly inaccurately depict the scene at 9122 Dexter back on the 19th of July of 2020 when you responded to it?
Yes,
All right. Now, may I approach, Your Honor?
Yeah.
Now, you mentioned briefly that when you first arrived, you observed a male on the ground in front of the Coney Island.
yes,
And I'm going to approach with what has been admitted already, Your Honor, if I may.
Yeah.
With 11, with People's Exhibit number 11. Would this be the individual that you're referring to?
yes, this was the individual that was in the parking lot.
Now, when
What
you,
exhibit is that?
this is 11, Your Honor. Now, when you were at that particular scene on Dexter on the 19th of July of 2020, were there some tasks or duties that you were asked to perform?
Yes, so I have a department issued fingerprint reader on cases where we have victims, where the person is a Jane or John Doe. I utilize the fingerprint reader in order to get us an identification on the victim to help with the investigation.
And is that commonly used in the homicide section, specifically in the task force?
Yes,
Okay, and is that something that you utilize in regards to this particular investigation?
yes, sir.
Now, the exhibit People's number 11, did you utilize that technology with the individual that's depicted in People's number 11?
Yes, I did.
Okay, and specifically, what did you do?
I took, on this specific case, well, in all cases, the fingerprint reader requires 2 separate fingers to be registered onto the device. And then those prints are uploaded into the APIS system, where it is matched against potential fingerprints.
Now, I see something that you brought up to the witness stand to your left. Is that the actual device that
Yes,
we're
sir.
talking about?
Yes,
Would you mind showing that to the court? And specifically, where would you actually put the fingerprint?
so the fingerprint on here, sorry, goes on this part here, and once the finger touches this metal part, it will scan the image onto here. I can turn it on if you would like, and when I log in, it will make me use my finger to do it, and you can see how it captures the print.
Okay, I don't think the court, it's
Okay.
necessary for this court. Now, did you utilize that technology with this individual?
Yes, I did.
And what were the preliminary results that you received?
Once this John Doe in the parking lot was fingerprinted with the fingerprint reader, the name came back to a Brian Jackson.
Okay, and then once that information is given, is that relayed to other members of your team?
Yep, so we'll usually take a picture of the information that comes up. It'll give you a first and last name, and we'll give you their system ID number along with a TCN, which tells you when they were fingerprinted, along with the birthday.
Was there any other individual that came up when you scanned the individual that you'd identified at first as John Doe in that particular photo?
No, there was only one name that came up off of 2 prints that I submitted.
Now, when you were at the scene, did the medical examiner's office come in and retrieve the body?
Yes,
Do you give this information to the medical examiner's office, or is that a separate function?
there's times where we'll give it to them as a preliminary. I don't know, I did not give them the information that day. I don't know if anybody else did. But on that day, I believe when they picked him up, they were still John Doe's.
And your testimony is that when you entered those fingerprints into your biometric scanner, it came back to a Brian Jackson.
Yes,
Do you remember what the date of birth was?
I'd have to look at my report.
If that refresh your recollection, go ahead.
I did.
Or do you need the
Yeah.
physical report?
AFIS, AFIS.
And just for the record, what is APIS?
Yep, automated fingerprint identification system.
And what specifically does that do, or what is that?
So that's linked with the state. That's the same system. If somebody's arrested and you're brought in on the live scan and they're fingerprinted, and it gives you an identification on who that person is. And then the reader also links into the FBI fingerprint database as well.
May I approach, Your Honor? All right, just for identification purposes, do you recognize what I'm handing you?
Yes,
And what is that?
this is my report that I would have submitted, detailing that I utilized a fingerprint reader to identify the John Doe's at the scene.
And does that refresh, does looking at that report refresh your recollection as to the date of birth?
Yes,
What was that?
It is June 30th of 1986.
And that would have been for Brian Jackson?
Correct.
Did you utilize that technology on any other individual at the scene?
Yes, sir, I did.
And where would that individual have been located?
That was the individual that was inside the Coney Island?
And did you do the same process as you did with Mr. Jackson?
Yes, sir.
And what were the results of that analysis?
The results from that came back to Carnell Watts, CarnellWatts.
And was there a date of birth?
Yes, 2/6 of 1996.
All right, Judge, I have nothing further. Thank you, ma'am.
Just a few questions. Is there anything about this portable device you have that could give you a faulty reading?
I have never had a faulty reading, no.
You know how to use this device, is that correct?
Correct, sir.
And you've been given instruction about it, is that correct?
Yes.
To your knowledge, is there anything that could give a faulty reading?
So if you don't have a full set of fingerprint, or if you are not putting down and there's not a good read, it might give you multiple hits, which is where it would say like 1 of 5, it would give you 5 possibilities, depending on how many points are matching from that fingerprint.
What about if there's any dirt or blood or any other substance on the fingers itself?
No.
No?
Anytime I have, if I'm using a fingerprint reader, the finger that I use on the reader, I make sure it's clear of any debris.
All right. And did you do anything else to confirm your results? Did you look to see if there's any driver's license on them or any other forms of identification?
I did not know.
And that's the same with the other subjects as well.
I believe the other subject, I believe there was a ID found, but I did not recover it, so I can't answer to that.
And you did not look and see, is that correct?
No.
All right. Nothing further.
No regret, Judge.
Right, thank you.
May this witness be excused, Judge?
Yes.
Sorry, Judge, one moment. Right, Judge, I have shown defense counsel what I have marked as people's proposed exhibits 40, 41, and 42. These are morgue photos that were taken along with the medical examiner's reports that have been admitted as people's exhibits 1, 2, and 3. They're the corresponding photographs. I'm going to move the revision under 766.11b, which is the hearsay exception. They're attached to the medical examiner's report, and they're only purposes of identification.
No objections.
Right, we good.
Thank you, Judge. And just
Just
for
for information, 40 is a photo of,
40, Your Honor, is a photo of Carnell Watts. 41 is a photograph of Brian Jackson. And 42 is a photograph of Courtney Willis. Your Honor, I also have what I have marked as people's proposed exhibit 26, and it's a stipulation for purposes of the felon in possession count. That's signed by both myself and Mr. Schlaf, and I'm going to move for its admission.
For preliminary exam purposes.
all right, we
No
good.
stipulated.
Exhibit what?
That would be exhibit 26, Your Honor. And may I read the stipulation into the record whenever the court's ready?
Yeah.
Thank you, Judge. I have entitled what is marked as People's Exhibit 26, State of Michigan in the 36th District Court in the County of Wayne Criminal Division, People of the State of Michigan versus Mickey Dane Douglas. And it's a stipulation that both parties, the defendant, his counsel of record, and the people of the State of Michigan stipulate that the defendant, Mickey Dane Douglas, for the purposes of count 5, felon in possession of a firearm, has been previously convicted of a felony. Further, Mickey Dane Douglas did not have the right to use, possess, transport, carry, sell, etc. a firearm at the time of the alleged offense because his requirements for regaining eligibility had not been met. It's signed by myself, Michael Sean Glenn, the assistant prosecuting attorney, and James Schlaf, the attorney for Mr. Douglas, and it's dated 1/14/21.
All right, we good.
Thank you, Judge.
Correct. Exam purposes, yeah.
Now, Your Honor, I did provide the court, as well as defense counsel, an updated copy of the people's proposed exhibit list. And I believe that the people have admitted exhibits 1 through 22, 26, 27, 28 through 34, 37 through 39, and 40 through 43. I just want to make sure that the board's records reflect the same.
Any remarks, Mr. Shaw?
I'm sorry,
Any
Judge?
remarks? Any comments?
No, I'm sorry.
Okay.
Your Honor, with that, the people have no further witnesses, and the people would rather.
And the defense has no witnesses either for these proceedings.
Ready, argument?
Judge, the people are going to move to bind the defendant over as charged and reserve argument.
Any arguments?
Yes, Your Honor, I would oppose the bind over on first degree premeditated murder in all these instances. As the court recalls from the testimony and from the view of the pictures, that we had a situation here where the defendant and his girlfriend were at the counter of the Coney Island, supposedly ordering food, I believe, and there were a group of people behind them. And as you can see, the best you could from the video, very animated people, and they seem to be going all around. Some were sitting, but everyone seemed to be talking. And some remarks were made. About shoes, my client's shoes. And in the community, these type of remarks about somebody's shoes, about somebody's coat, about somebody's glasses, often is a prelude to an attack for robbery purposes, to seize these items. And my client was at the counter, as you could see, he turned around, he took a gun and started shooting. There wasn't much time in between, according to the testimony, I believe. It just happened. And I believe that takes away materially from the premeditation element that's necessary for it. Now, I understand that premeditation is something that who knows how much time you need to think things over. But at the same time, Your Honor, in response to something like that, and as you could see, it was almost immediate and perhaps even automatic. And I believe that this makes for a viable self-defense at trial, although something that we can't assert here. But I think that goes into the circumstances as well. So based on what you saw, and based upon what the testimony was, and the woman who testified, and all those things, I don't think we have a murder one situation. It's more murder two at the most. So if this court is inclined to bind over, I would ask it to do so on a lesser charge.
Any vote?
Yes, sir. You know, I certainly can respect counsel's argument regarding what the evidence that was shown in the preliminary example. We didn't just hear testimony. The court actually had an admitted exhibit that showed the execution of 3 young men for no reason. In fact, the testimony wasn't that it was going to be a robbery. In fact, I believe with the witness
Shooting the 3 young men.
of the shoot.
Two.
No, there are 3 individuals that were shot and killed inside of the Cognac. There are three young men that have been murdered in this particular case. There is a 4th individual that was also shot in the head that the court can view on the video that survived.
Okay.
So in terms of this particular case, Judge, when you look at the premeditation, you're allowed to actually look at all of the facts and circumstances before, during, and after that particular case. But what's the most telling, even without the testimony of the girlfriend of the defendant, who was in there at the time of the shooting, what you observed in the particular video is the defendant messing around in his right pocket. You see him messing around at the counter, and for 10 seconds prior to the shooting, you can see the defendant try to pull the gun outside of his pocket. So what does he do? Once the shooting starts, he finally gets the gun out, walks right up to Courtney Willis and executes him, shoots him right in the head. Then he turns to Brandon Mosley, shoots him directly in the head. Then he turns to Carnell Watts and shoots him directly in the head. Then he runs after Brian Jackson, the person who was killed while he's running away, shoots him 4 times in the back. Then returns on video to shoot back at the 3 men that have been shot inside. To return back outside to try to shoot Brian Jackson again. That's all on video. I mean, how much more premeditation do you need at that particular point? I mean, for probable cause standard, you can certainly weigh the pros and cons of one's actions. You can certainly see that he was thinking about that. But where you're pointing, who you're going to shoot, how you're going to do it, that's methodical. That's methodical action. Not just a spur of the moment, oh, I'm just going to shoot everyone else. But when you look at these 3 individuals that were inside and the one that ran outside, the victims in this particular case, they did nothing. In fact, the first individual that was shot, Mr. Willis, was turning away. No one was looking at the defendant at this particular time. And then he shot them continuously and then ran away. Judge, I mean, when you look at it in its totality, probable cause. Thank you.
So having heard the testimony and argument, time for this power. Hearing testimony first of Ms. Danielle Miles Garrison, who known the defendant for 2 years. He was her boyfriend. That she owned a 9mm that she bought from a pawn shop and closet at home. She has seen the defendant with her gun prior. That on July 19, 2020, went to 9127 Dexter, which is the Eagle, Coney Island, and then drove them there in a white pickup. Then it was wearing a red shirt and jeans. She went inside. A few minutes later, the defendant followed. While inside, she said that at least one of the gentlemen, in this case, the victims in the case, said something about having nice shoes. And then that they said those are the type of shoes they take off people's feet. And she said, then her testimony, then there was a shooting. And combining her testimony with the video that was shown to the court that the defendant admitted, I couldn't hear anything on the video, so I don't know what was said. I had to hear what was said from the witnesses. I can definitely see the actions at that point. The defendant, who was basically standing at the window, the other 4 individuals, 3 were to his immediate left, and 1 was to his left, kind of behind him. He then not only turned towards them, but walked towards them with the gun outstretched and shot the first victim basically point blank. So it turned to the other one, started shooting them. One guy ran out the door. The defendant followed. We can't see what happened, but the aftermath, I mean, is obvious from the exhibits given and the medical examiner's report. The defendant was shot multiple times back. He then returned inside, shooting again. I understand the argument. Trust me, I understand the argument. I grew up not far from where this happened. Still live on the west side of Detroit. And although I would agree with council's statement that, making a comment about the shoes, saying nice shoes, especially follow up with those are the type of shoes you take off of people, may be considered, a kind of first step towards some type of other action, including some type of robbery. But in this case, the comment was made and nothing happened. At least nothing happened from the standpoint of the people that made the comment. They made no movements, they made no gesture, they made no motions as to go towards the defendant as if to assault him or do anything to him. They were just, at that point, it appears to going about their business. They made the statement and that was it. Maybe, no, put your hand down. I'm not going to, think why they didn't, but the fact is they didn't. The defendant then made the motion. He then made the action. He then shot them point blank. He had more than enough time to think about what he was doing. So at this point, the court's going to bind over on all the felonies enumerated in the complaint and warrant, find that they in fact did occur in the city of Detroit. Probable cause exists to charge the defendant. Will be bound over to Wayne County Circuit Court of Criminal Division for arraignment on the information, which will be January 21st at 9 o'clock.
Thank you, Judge.
Thank you.
I'll get in touch with you.
They found the 40 Smith and Wesson, and he put his hood on. After they said the comment, he put a hood on his head. On top of holding it inside the pocket. Come on.
Yes, ma'am, please. Thank you so much. Thank you.
Tonight, huh? It's 7:30 tonight? Are they opening at home?
Yes. If they are on tonight. It's just a shame we can't go with my show.
We usually get to some games every year.
What?
Every year.
Oh,
We're talking hockey.
oh.
Who's next?
I think I'm seeing you tomorrow via Zoom.
Bumpington.
Okay. All right, so you know we're starting back with the exam.
Say, your appreciation.
I mean,
No, this is
for everybody.
for everybody.
Yeah.
No, that was
Mr. Cooper.
I like that jacket.
Mr. Cooper.
Oh, that was Mr. Cooper?
It's okay if you see more of us then.
He's sitting right there,
He's
John.
supposed to be in here, he's our representative on this, yes.
Oh, did you do the new PE?
No, yeah, I actually looked at it.
Oh, did you? Okay.
Yeah.
Just wanted to make sure I got it for you.
I'm fully digital now.
Judge, and that approach unrelated, completely unrelated.
What up?
Mr. Cooper, you just watching on Zoom?
I was watching on Zoom, yeah.
Oh, you were watching?
I'm sorry, yeah, I was.
Oh, okay.
Right on the
I was
hallway.
like, he's supposed to be in here, really?
Right now. Fine, if you're here on Buffett. Oh, I'll have a word with him, sure.
He's up here?
Thank you.
No problem. In fact, I thought over there.
Okay, and,
Yeah, I saw that.
page.
Yeah, I watched that whole video.
It's further south. But it's further south, all the way down to south. Don't get everything.
So like Monterey, like way down there.
Yeah, way down.
That's beautiful.
Yeah, way down, no hurricane.
Oh my God.
Weather settings, winds go down.
Gorgeous. When I saw that, it was one of the first comments I made.
Yes. That video.
It's a great place. All right.
I'm gonna check it out anyway, though.
I hope you should,
They
Judge.
have, I get this thing called, it's called Ideal Living. They have a lot of retirement places, you know, different places all over the United States and parts of the world. where you can
439 just Johnson.
And there are a number of places they live in Los Angeles.
It's just gorgeous. I mean, the people down there were really friendly. They understood, you know, this is, you want to relax, you want to be, it was beautiful. Just, oh,
Yeah.
I'd move there if I could. I would, I'd make heck of this. Probably zoom in, maybe.
Yeah.
Have a wonderful day, everyone.
All right, you too now.
You too.
Judge, I think this is my last one with you for now.
I was just gonna ask, when we seeing you?
I think for some reason it's been Judge Archer. I go through cycles. It was you for a long time and then it's just Judge Archer now.
That's we rotate.
Yeah, the case.
Rotate a little bit.
That's a shame. I like him back here. Look, I like being pushed. I don't learn anything unless I'm being pushed and thrust and that's great. All right, take care, everyone.
Take care.
All right, see you, Mr.
See you,
Glenn.
sir. Always a pleasure.
Be safe.
Yes, ma'am, you do the same.
Thank you, I will. What is your name? Johnson, Gordon Johnson? Okay, you're not on the first down, that's the thing, no. No. I know, no, son, I can't say that.
Appreciate it.
Wow.
Get it ready for you. You just get it ready. I hear you. He's gonna be sitting in the back or is he? Okay. How's it? Everything good?
Everything good, how you doing?
I'm all right. I mean, staying in the house so much.
Okay, where's your paperwork? You don't have your case
I'll
number?
I'll just come down and.
Okay, you don't have to
I mean, I really,
Sir, sir,
you know, I know it's not
Mr.
safe
Johnson,
or
Mr.
as
Johnson.
safe as being at home.
you're gonna have to call.
Get in there.
We're in session.
Yeah.
Can't do it.
I know.
Go back.
But what you gonna do?
I'm taking a couple weeks in March. And I'm going down to Costa Rica.
Oh, great. Oh, that'll be real
Oh,
good.
we need the prosecutor, right?
That'll be real good.
Here?
I think it's the sheet.
Normally, you know, at least 3-4 times a week comes on somewhere.
No prosecutor out there more?
I think
She's in the room. Is she
I have to
zooming in
leave, I
or?
have to go.
Huh?
She's zooming in.
Yeah,
No,
you know,
she should
I
be
can't
in here.
stay here, I refuse to stay at home. But this year, you know, I took basically no time. The 2 weeks break from my life. And,
Huh?
you know, and Kelly.
Oh, okay.
as he kept
Yeah, I'm
saying,
ready, I'm waiting on the prosecutor.
Kim made it drive.
Okay.
She's
on her way.
I did it.
Devin and stuff.
You know, 'cause you wanted to, but I never knew it again.
Right.
I'm gonna get a full hazmat suit and go sit on the airplane. It's the oxygen tank. I don't want oxygen for afterwards.
I hear you.
I'm not driving like that again.
That was a little torture, huh, Judge?
Little torture.
I've been too old for that.
Yeah, age, start finding out things about yourself so you can't do anything, okay? You know, the gaining weight part is really funny. Wait a minute, this is when I finally put some real advance on, these are too tight.
Yeah, normally, especially this time of year, I'm usually in about 3 different leagues, basketball leagues.
Let's see, you're having
Including a travel league.
Oh, really?
But I have not played since last February.
Yeah, but I mean, it's not like nobody's
30
playing.
pounds though.
Nobody's playing though, so.
Yeah. I know, but the problem, at my age, that's where it's tired. So, that's it, it's not like, 30 or 40, and I can sit for a month and do nothing, get up.
Yeah, but you
Get back
can't
in
do
shape in
that.
a couple weeks.
Right, I mean, I'm already.
Now it's like, okay, it's gonna take me 6 months to try to get back to the shape I was in.
I ordered equipment and then Amazon dropped it all off. And I'm too weak to put it together. I have really lost a muscle mass. And I don't let anybody come over. So I'm just looking at it in the regular, I'm like, okay, I'm gonna get to this. All right.
You ready?
Yeah.
You ready? Calling case number 20-61354, the people of the state of Michigan versus Lamont Buffington. Defendant is charged with count 1, criminal sexual conduct, first degree. Count 2, criminal sexual conduct, second degree. Count 3, criminal sexual conduct, second degree. Count 4, criminal sexual conduct, second degree. Count 5, criminal sexual conduct, second degree. Count 6, criminal sexual conduct, second degree. Count 7, criminal sexual conduct, second degree. Count 8, indecent exposure. Count 9, indecent exposure. Count 10, indecent exposure. This matter is scheduled for an examination.
Good afternoon, Your Honor. Reagan Lake P7043 on behalf of the people.
Good afternoon, Judge. Renee Cooper on behalf of Mr. Buffington, who's present in the courtroom. I'd ask witnesses not testifying be sequestered, and I'd ask Madam Clerk if there's an extra complaint in the file.
You want to complain or information?
Well, then that information's till the bind over, so it may say information, but it's not really.
There's only gonna be one complaint. I can make a copy.
Oh, I mean, I don't want to put you through any trouble. I remember looking at those files and seeing a million of them.
That's the information.
I'll take
It's a lot of
one of those.
information.
It's the
You take
same
one?
information on it, yeah. I mean, it says it's an information.
Just one, Your Honor, we would join that sequestration motion. We do ask for an exception for the officer in charge, Detective Cecil Stevens, if he should appear.
No objection.
All right, witnesses testifying today at trial or any future hearing will leave the courtroom or be denied their future testimony. Just so the parties are aware, we are running on Zoom, and we're running live on YouTube. Right now, there's nobody else in the Zoom room, on Zoom with us, but I have no way of knowing if there's anybody watching it on YouTube.
And that was my next question, Your Honor. Is there a way, given the complainant's young age, she's 11 years old, that we can video record this and then appropriate editing be done so that her face is covered? I know that Judge King had that done in an exam I did with him last fall. So it's not shown live, but it is recorded and displayed, made available, but after sufficient action has been taken to protect the witness' identity.
Any comment, objection?
I have no comments.
All right, then, We're running it in the court and on Zoom, so the court's going to